Hi, my name's John Bayog. I'm the owner and founder at Bayog Law. I'm a Massachusetts-based estate planning attorney. In today's video, we're going to be talking about what happens if you die without an estate plan or with an incomplete estate plan. So if you die without an estate plan, that means you don't have a will or a trust in place. If you don't even have a will and you pass away, it's called dying intestate. Dying intestate means that you've died without a valid will that specifies how you want to pass your assets. Three big issues can arise when someone dies intestate. One, you don't get to say who gets your assets. The state will decide who gets your assets. Two, if you have minor children, you don't get to appoint guardians for your minor children. The state will appoint guardians for your minor children. And three, you don't get to appoint your personal representative. The state will appoint your personal representative. So in terms of asset distribution, when you pass away intestate, state laws called the intestacy laws take over. And they determine who gets what. They vary by state to state, but generally they prioritize close family. The intestacy distribution scheme developed by the state may or may not, be in line with your wishes. But I'll give you some examples of how it might not be in line with your wishes. So if you pass away without a will, according to the intestacy statutes in Massachusetts, your estate might get split between your spouse and your children, even though you wanted your spouse to have it all. Or you might have to share your estate. Your spouse might have to share your estate with your parents, even though you want your spouse to get everything. Or it might all go to your parents, even though you're estranged from your parents and you'd want your friends to get it all. Distant relatives that you don't even know could end up getting it. So there's all sorts of distributions that you might not be happy with that could occur by not having a will. Not only could these distributions be against your wishes, they could also cause conflict among family and friends. Additionally, the intestate probate process can become more complicated and time-consuming, causing a delay in the distribution of your assets. This can cause unnecessary stress and financial hardship on your loved ones during an already hard time. As for guardianship of children, having a will allows you to name guardians for your minor children. So if and when the time comes, there won't be a court process. It'll automatically be whoever you appoint to be a guardian will take over. Otherwise, if you don't have a will and you don't specify who you want the guardian of your minor children to be, it will be up to the state, and they might decide to go with someone that's entirely against your wishes. As for picking a personal representative is the one who's going to wrap up your affairs and close out your estate. So they'll be responsible for distributing assets, paying your bills, and just closing out your estate. If you don't choose one, the court will appoint one. And it's Massachusetts law that personal representatives they're due reasonable compensation. But I can almost guarantee a court-appointed representative is going to be much more much more expensive than one that you appoint. You can appoint anyone who you trust. It could be a family member, and oftentimes they'll do it for free. So having a court-appointed one, that's going to be money that's getting taken away from your beneficiaries. So that's what happens if you pass away without a will. But many people have wills, but they don't have a healthcare proxy or a durable power of attorney. So they have incomplete estate plans. So now I'll just touch briefly on what could happen in those scenarios. So what is a healthcare proxy? A healthcare proxy allows someone to make medical decisions on your behalf. What happens if you pass away without a healthcare proxy? If you become incapacitated without a healthcare proxy? Without a designated healthcare proxy in place, your family may have disputes over your care, especially if they have different decisions when it comes to life-sustaining measures or critical decisions. And that can lead to unnecessary delays because The court might have to get involved to make a decision, and that can delay necessary medical care. Having a healthcare proxy ensures that someone you trust is authorized to make medical decisions on your behalf, reducing conflict and ensuring that your healthcare preferences are respected. So what happens if you are incapacitated and you don't have a durable power of attorney? Well, durable power of attorney allows someone to make legal and financial decisions on your behalf. So similar to being incapacitated without a healthcare proxy, if you become incapacitated without a power of attorney, no one will have the legal authority to manage your legal or financial affairs. This means that your bills may go unpaid and your financial obligations could be neglected, causing unnecessary stress and financial hardships for your family. Without a power of attorney, your loved ones might need to seek a court-appointed conservator to have the power and authority to make the legal and financial decisions. This can be a time-consuming and costly process. Having a power of attorney allows a trusted person to act on your behalf, ensuring your financial matters are handled smoothly and according to your wishes. So I hope that helped clarify what might happen if you don't have a complete, or if you don't have an estate plan or an incomplete estate plan. I hope you found the video helpful. Please feel free to reach out to me with any estate planning questions. Take care. See you on the next one.